What if a customer gets hurt at your place of business? Business owners are responsible for keeping their premises safe and free from hazards, and to make whole those who've suffered injuries due to unsafe conditions at the place of business. But runaway jury verdicts and other unfair tactics are changing this dynamic. Welcome to Future of Risk, presented by Zurich North America. We explore the changing risk and resilience landscape and share insights on the challenges that businesses face to help you meet tomorrow prepared. This podcast mini-series is all about social inflation. The term social inflation refers to the rising costs of insurance claims and litigation that go beyond general economic inflation. Those costs are driven by societal factors rather than traditional market forces. Those societal factors include social attitudes, legal practices, legal system abuse, and cultural norms. The impact of social inflation goes beyond the insurance industry and leads to higher insurance premiums for businesses, a strain on the economy, and growing financial impacts on everyday consumers. Over the course of this mini-series, we've learned businesses face risks that can expose them to lawsuits and increasing jury verdicts. In our final episode, we're focusing on the shifting legal standards around premises liability. I'm Al Orndorff. Today, I'm speaking with James Beal, the Executive Director at Georgians for Lawsuit Reform, and Rebecca Fozo, Claims, Judicial and Legislative Affairs, Assistant Vice President at Zurich North America. James and Rebecca, welcome to the podcast.
Thank you, Al. Thanks for having us. I'm really excited to have this discussion with my pal, James.
Hey, good morning. Yes. Thank you so much, Al.
Rebecca, can you set the stage for us? You know, liability insurance, most everybody knows, pays for injuries that happen on your property. What is premises liability?
Sure, Al. So the technical definition of premises liability means a property owner can be negligent if there's a defective condition on their property, or they let a defective condition continue to exist after they maybe know about it, and then somebody gets hurt as a result of this defect. In those cases, the property owner can be liable. And there's usually some types of degree of reasonableness required on the part of the property owner. But what constitutes a defect and maybe what reasonableness means in plain English varies from jurisdiction to jurisdiction. Now, the easiest way I could probably describe this is giving you a couple examples. So think of a slippery floor situation. Maybe you're walking through the grocery store and somebody slips on a banana peel on the floor and is hurt. It could be something like a swimming pool accident where maybe the property owner did not secure the pool area and someone's hurt, or even negligent security where maybe the property owner fails to implement a security measure, like having proper lighting in a parking lot or surveillance systems, and the lack of security could lead to someone being hurt.
James, there's something called the duty of ordinary care. What is that?
Rebecca touched on the general aspects of a premises liability claim and what those are. When we talk about a duty of ordinary care in Georgia specifically, that is the duty that is owed by a private property owner or a business operator to the folks who come onto their property to do business or engage with them otherwise. And the law puts into place that duty of ordinary care by statute. And then what we've seen over several generations is a body of law developed in the court system that sort of tells us what a duty of ordinary care actually looks like. And right now the courts, to add a little bit more confusion to it, have called the duty of ordinary care a duty to provide reasonable care. And then it kind of builds off of that. And so what we've seen over the last several years, again, is the development of law surrounding what that means based on jury verdicts and interpretations by our higher courts. And that's sort of the way that most states will handle that. But in Georgia, we specifically have no framework in our statute that speaks to what a premises liability claim is, with the exception of that duty of ordinary care.
Thanks, James. Rebecca, in your earlier comments, you had laid out some incidents that can become insurance claims. These same types of incidents, can they end up as lawsuits?
Yes, Al, they can. These types of premises incidents can certainly evolve from a claim into a lawsuit. And we work with our customers and our claimants to make sure the injured party is whole if there is liability. But sometimes the parties disagree as to whether there's liability or what it would take to make somebody whole. And that's when a lot of times we'll see these claims develop into a lawsuit. And each of these claims that maybe do develop into a lawsuit are different, and they rise and fall on their own sets of facts. So we need to do a thorough investigation as to things like maybe what happened to the injured party, what the condition of the premises were the premises owners reasonable in maintaining their property, those sorts of things.
James, any thoughts? What happens when the unexpected happens?
Right. When things go sideways, so to speak, we see these claims sometimes turn into lawsuits. As Rebecca mentioned, they can become filings in court, and you go through the whole process. What we've been saying around the state capitol here when we talk about it, the rigmarole of a lawsuit and getting dragged through that. And in Georgia specifically, we have seen standards surrounding these laws kind of go sideways themselves. We've seen runaway verdicts from shifting legal standards. And one very infamous case now is a case called Carmichael versus CVS. And obviously CVS is a large company, but we also see claims against small businesses based on these runaway verdicts, these cases that get appealed, they go to a higher court, and they set new standards for the law. So when we hear about some of these bigger runaway verdicts, it's usually against what is perceived as deep-pocketed industries, but it impacts small business owners themselves, not just businesses, but also on the public side of things. We see cities, right? In Georgia specifically, we had a fairly recent case with a city in north of Atlanta in the suburbs. Pretty interesting set of facts. The city had a city street in which a planter had been in the street since before the city had been incorporated. And sadly, an individual hit that planter and was injured, and that became a lawsuit against the city. And that resulted in a huge verdict against the city. From there, those costs, obviously, they go beyond whatever the city had in place in the form of insurance, if the city had insurance, so on and so forth. And that cost gets passed down to each and every taxpayer in that particular city. And you talk about, Al, you talk about social inflation. Well, I don't think that there's a better definition of inflation hitting a taxpayer than one of these runaway verdicts that are based on a shifting interpretation and shifting legal standards of premises liability claims. In that particular case, it's resulted in about $700 to $750 coming out of each and every taxpayer in that jurisdiction, coming out of their pocket and going to the plaintiff and the plaintiff's attorney in that particular case, all over a planter on the side of a city street that had been there since before the city was even incorporated. But, you know, like I said, these things impact everyone, and it'll impact subscribers to insurance when in the form of premiums that they have to pay that are higher. It'll hit taxpayers who are simply trying to do business in the city or the county. It hits everyone. We had a rural hospital who had to drop its OB care because of their liability insurance. And when they dropped their OB care, their premiums went down, I think, 17%. And so that's the only way that the full hospital could stay open. A family who heard about our tort reform efforts in the news cold called me to tell me about how they were dragged through a frivolous claim for 8 months. And this was just a family in suburban Atlanta. And at the end of the day, they got through depositions and discovery, and they finally deposed the plaintiff, who was their neighbor, and the neighbor had no idea what was going on, and the attorney just dropped the case. So that was 8 months of having a $111,000 demand hanging over their head that went nowhere, that they had to pay to fight. I have example after example, especially from our farmers who are working hard to put food in grocery stores and getting food to our tables. I've got restaurants who simply just want to serve the public and provide jobs in these communities. I've got independent grocery stores in rural communities who, we had a snowstorm recently. One of them opened up and got sued twice. 2 lawsuits were filed against them for incidents that happened in their parking lot. And that was them just wanting to open up during a tough time for their community, because snowstorms are not a regular occurrence here, but they just wanted to open up and serve their community. And it is getting out of control here in Georgia. And this year we need to get this tort reform done and provide some stability.
And James, you mentioned something particularly interesting in that I think a lot of us know that many of these jury verdicts target organizations that are perceived to have deep pockets. What you're saying is that is actually leaching further into the system, and the deep pocket targeting is actually also affecting businesses that may not have as deep a pockets, but it's the environment that has been created that is affecting everybody, not just those organizations perceived to have a lot of resource.
Yeah, Al, you've nailed it on the head. When we hear about the runaway verdicts, if a defendant can't afford it, or their insurance doesn't cover the full amount, or what have you, they'll be on the hook for that. But what you don't hear about are these smaller claims, these claims against smaller businesses that are not in and of themselves a high dollar amount. But when you think about a small business operating on tight margins, it is a huge amount for them. A $30,000 payout might be huge, and maybe they have insurance that can adequately cover that, but the cost of that will get passed down in their premiums, and then it'll get passed down to their consumers. So let me set the stage for you here a little bit, Al, and kind of going back to that reference I made to the CVS case. What that CVS case did was, yes, it was a plaintiff who was tragically injured in the parking lot when they were involved in some sort of deal with another private individual over an iPad or something. And then they sued CVS, and CVS was found to be 95% at fault in that case. And the individual who was injured was only 5% at fault, but the shooter was found not at fault at all. They were not considered to be at fault. Kind of an interesting case, but the bigger piece of that was that when that case was appealed up to our state Supreme Court, they adopted a new legal standard, which doesn't just impact CVS, doesn't just impact large businesses, it impacts the whole state. And it was a single jury verdict from a single county here in Georgia that now has statewide impact. And so what you see is that changed the legal standards for what evidence you can introduce. That makes it more difficult for a defendant, aka that business, to go to court, to have a fair shake in court. And you will have an attorney, a plaintiff's attorney, who will use that verdict, and they will go after every business, doesn't matter, small, large, medium, what have you, and they will use that to their advantage in enforcing these settlements. And it could be the most frivolous claim. So we talk about frivolous lawsuits. Well, let's talk about frivolous claims. When you have a legal environment that allows for that, then the claims themselves can be frivolous, but hey, I could roll the dice and go to court and risk a $40 million payout. So that's what we're talking about. And what we want in Georgia and what we're seeking is to put some statutory framework in place in which judges, juries, and both parties can rely on and provide them with a fair shake in court.
You just done a magnificent job of describing what we alluded to at the very start of the program, the systemic impact of social inflation on the entire, justice process, which is why we're talking about it, which is why we are working to do something about it. Let's dive a little deeper here if we could. I understand there's an interesting dynamic playing out that is increasing premise liability cases, especially in states like Georgia. James, what about that?
What we're seeing more and more of is when there is a lack of a statutory framework. That means the folks that we elect to the state general assembly here in Georgia, when they don't speak on something, they don't create policy, they don't put it in statute, then it becomes solely up to whatever story a plaintiff's attorney can make in court. And it will pull on the heartstrings of juries, and the juries do their jobs. But what we're seeing is because of the lack of these standards in state law, we're seeing more and more runaway verdicts. We're seeing more issues get put in court that probably shouldn't be in court, shouldn't be gumming up the court system. It's either these frivolous claims that then become lawsuits, or it's these frivolous claims targeted at certain businesses. And, if, like me, if you follow some of the jurisprudence here in Georgia, you can see where premises liability is potentially, especially the negligent security claims, there is a piece of premises liability called negligent security that we're seeing more and more claims over, and some of these have resulted in lawsuits. And again, these will target deep pocket industries, but they're trying to use the court system to get at other even more deep pocketed industries like the franchisors of companies. You will see, for instance, your favorite fast food restaurant, your favorite hotel that you stay at. A lot of these are operated as small businesses, but they're franchises. And so they'll try and use these negligent security claims to push the law in their favor in order to pierce this veil and get at franchisors. That's just one example.
Yeah, it's a great segue to the next question. That is, are there certain types of businesses that are typically targeted for these premise liability lawsuits, or can this impact any business?
Yeah, it can impact any business. And again, when you have deep pockets, you are already a target. We hear it was just yesterday, or maybe this morning, actually, there was an article that was put out about a horrific set of facts that were targeted at one specific, very national, deep-pocketed nonprofit. But they have a national presence. They're in every community, in Georgia anyway, but I think across the country. And what it is that there will be a horrific set of facts in which you will feel that someone needs justice on that. But at the end of the day, when you lack some statutory standards, whatever the outcome of that case is, especially if it's a runaway verdict, so to speak, a big payout, a lot of times that will be appealed because you feel I didn't get a fair day in court. And so anyone that has a large presence nationally, or at least in Georgia, is potentially a target for these. And that's why it is so imperative that we get tort reform done this year.
Rebecca, one aspect of this issue that we haven't touched on yet is outright fraud from a claims perspective. How much of an impact is this having on making a bad problem worse?
Al, I think you said it exactly correctly. I think this is making a bad problem worse. Many of these claimants who will create a horrific set of facts, like James was talking about, will stage something like a slip and fall accident on a property. And a lot of times they'll actually scope out the area before they have this fraudulent accident, or maybe they'll see there's not a lot of traffic in the area, or they know there's no surveillance cameras, or maybe the surveillance cameras aren't working. And they'll actually have somebody fall there over something that would a lot of times be considered an open and obvious defect, something that they can see. And then they'll actually fall and create a claim. And then they'll have this other person witness another person's accident. So there's a whole segment of these fraudulent types of claims where, yes, certainly you do feel bad for the injured person, but the conditions under which these claims were created are simply fraudulent.
As difficult as this issue is, it is not without solution. And so I wanted to kind of wrap our conversation today by asking what can be done about this?
Well, I can definitely chime in. on that from risk management, some practical tips, some considerations to do if you're a company and you do have certain policies or procedures in place. Make sure that your employees are aware of those policies and procedures. Make sure you're documenting in compliance with those policies and procedures. And one thing that we are noticing is that juries want to see a video of an accident. We're just so accustomed to seeing videos now in this day and age. Make sure that your company is retaining the video footage. And I would suggest not just of the accident itself, but the 24 hours before and the 24 hours after. And I know that seems like an awful lot of video footage. However, we're starting to see more and more judges allow that type of request. It would behoove your corporation to be able to produce a video that maybe has really nothing on it than to face a potential spoliation of evidence claim where the plaintiff's attorneys are definitely going to say you intentionally destroyed the evidence, and then you have to face the jury with that particular issue.
Yeah, which puts you behind the 8 ball at the start.
You got it.
James?
Yeah, I can talk a little bit about what we're doing here in Georgia, and that may be impactful to other listeners in other states. In Georgia, we have been fighting for meaningful tort reform for many years, and this year we have our governor Brian Kemp and our state senator, who is also the Senate President Pro Tem, John Kennedy, both leading the way to get this done. And Governor Kemp stepping up and taking this issue on has been a game changer here in Georgia, and very much appreciate him taking this on. It's been a multi-year effort for him as well. What he decided to do and what the General Assembly decided to do was gather insurance-related data from our insurance commissioner and review that to not only start talking about it, but to have data that backs up the anecdotal stories that we hear and the folks that come forward and say, hey, this is where I got hit with this claim. This is why the cost of doing business is so high. Here's why I can't get insurance anymore. Here's why I had to fortify my parking lot and make it more difficult for customers to come onto the property, so on and so forth. So we have the data now to back up the stories. I think that was a very wise move on the part of our governor. But at the end of the day, I can't tell you how many groups I've told this same thing to, but folks in the state capitol here in Georgia, we've done everything that we can to highlight this as a problem, to overcome the most special interests in this building who want to see nothing changed. And it's hard to negotiate. It's hard to come to a deal, so to speak, with a side that doesn't want anything to change. And that's what we see from trial lawyers. So what we have done here, we have put an emphasis on grassroots efforts. And if any of your listeners are here in Georgia or they're seeing issues in their own states they're hearing from their policyholders, their clients, so on, or they see it themselves, maybe they have a side business, a bookstore, or what have you, something on the side. If they feel that they can't rely on the law to protect them from frivolous claims, frivolous lawsuits, then they should get engaged. They should find out who their state leadership is, who it is here in Georgia, and start that grassroots efforts to reach out to their legislators. And that has been a true game changer. We have our next subcommittee hearing tomorrow in the State House. We're going to have some good folks come and not just talk about the legal aspects of the bill, but also to share more stories about how difficult it is for them to navigate our current legal environment here in Georgia. I'm confident that we can get something done, not only because of the efforts of our governor and of Senator Kennedy, but also because of just the grassroots engagement here in Georgia.
An issue that drains resources also requires resources to fight it. An outstanding conversation today. Thanks to James Beal, the Executive Director at Georgians for Lawsuit Reform, and Rebecca Fozo, Claims Judicial and Legislative Affairs Assistant Vice President at Zurich North America. And thank you for listening. If you like the show, leave a comment or review wherever you get your favorite podcast. Or you can drop us a note at media@zurichna.com. All of our social inflation episodes are available at zurichna.com. This has been Future of Risk, presented by Zurich North America.
Future of Risk, presented by Zurich North America. If you like the show, we'd appreciate it if you left a comment or review wherever you get your favorite podcasts. Let us know what you think at media@zurichna.com and join us next week.
The information in this audio recording was compiled from sources believed to be reliable for general information purposes and is intended for Zurich clients and business partners. The information contained here may be useful to you or your enterprise when developing your own policies and procedures. The policies and procedures applicable to your enterprise should take into account the specific circumstances of your business and business environment, which is beyond the capacity of this podcast. Any and all information provided is not intended to constitute advice of any nature and is specifically not legal advice, and accordingly, you should consult with your own legal counsel. We do not guarantee the accuracy of this information presented or any results, and further assume no liability in connection with this recording and the information provided therein. Moreover, Zurich reminds you that the information provided cannot be assumed to contain every acceptable safety and compliance procedure, or that additional procedures might not be appropriate under the circumstances. The subject matter of this recording is not tied to any specific insurance product, nor will adopting these policies and procedures ensure coverage under any insurance policy. We encourage listeners to seek additional information from credible sources. Thank you.